I gather that it is a hard act to follow this morning's panel, but hopefully we will make this afternoon relatively entertaining for you as well as quite thought-provoking. I said earlier on to Arianna, who's going to follow me, what I'm going to talk about today feels a bit like the story of my life. Because I have been in Brussels and, like us all, very much living through the last few years of the financial crisis, and my thoughts that as to what I would say today were based first and foremost on the first things that came to my mind, and then I did some more reading, and then I did some more researching, and I looked at the outline and the way that we had discussed it, and I think I changed absolutely nothing. So it's a real pleasure to be here. It's a real pleasure to be in Edinburgh, even though the weather is like this. And it's a real pleasure to talk to you on three subjects: competition policy, competitiveness, and the European financial crisis. Well, you can see that the slides are very topical. They are in full colour. I seem to recall sitting in this very lecture hall with a pen, and I used to write with a fountain pen in those days because I found that I could read it back later. And there was certainly no visual aids at that stage. So I thought, well, if there's one thing that I can do for you just after lunch, it's give you something nice to look at. So these are slides which are intended to be a little bit thought-provoking, not to tell you exactly what I'm about to say. So what am I going to do? I'm going to start by talking about competition policy. Now, maybe this is too basic for everyone, but I think it's always quite good to go back to first principles. So what is competition policy? What are we talking about? Well, competition policy is the basic view, as I always tell students that I teach in the very first lecture. The idea is if you have open markets and companies are encouraged to compete and not collude, and there are laws there to prevent them from colluding, there will be certain advantages. And what will those advantages be? Well, simply, there will be a decrease of prices generally in the market. There will be increased innovation when we look at the products that come to the market, and there will be more choice. What does that mean? Well, that is a good thing, in simplistic terms, for consumers. So competition policy is something that's important for consumers. Competition policy is also something which is important in terms of the structure of the market, because if you have the forces of competition working to a certain extent, the argument goes, you will have faster restructuring of industry in a difficult situation. You will have an industry in markets more able to compete globally, more able to compete with the competition coming from outside the market because of what they have experienced and what they've gone through. So the argument is competition policy is good for economic growth. But when you look at competition policy in the EU, there's a very important finesse, because competition policy, when it was in the minds of the EU founding fathers, had another very important element. So if we go back again, 1957, the Treaty of Rome. Very simple aim, it was to prevent more war in Europe. How would that be done? Well, if we can encourage greater prosperity in Europe, encourage European growth, there will be political stability, and we will live in a more peaceful environment. How will we encourage economic growth? Well, we will use competition policy, and that will be a key element in what we consider to be the driver of economic growth, and that is creating this European internal market. Now, it took a long time for the European internal market to be created, but from the word go, the idea was that competition policy would be there to back up the legislation. Because if you had legislative initiatives stopping governments from creating barriers to trading across national frontiers, that would all be wasted if you had companies that could come along and have their own agreements to partition national markets, to create national champions, to agree amongst each other that they would market share to ensure that they were protected from competition, and also to agree in the way they would distribute goods or the way they would have licensing agreements to have separate markets. And the result would be that companies were not competing within the European market, but were only competing in their own national territories. So competition policy in 1957 was considered as an essential way to ensure that companies were prevented from making barriers in the European community, and that they had to compete in the wider market and they couldn't install barriers. And so competition policy, apart from having all these good things that I talked about at the beginning, had this element which was to stop companies imposing barriers to trade across frontiers. What we see now, I think, is that competition policy, the orthodoxy, is very much accepted. And what we see now is the European idea of competition policy being propagated into the member states. That's been a very key development in the last few years. And what we see over the last few years is competition policy and its importance as a driver of economic growth being a topic which is very often put forward by the European Commission in particular. So competition policy in legalistic terms, what does it cover? It covers what we often call now kind of antitrust side of it. That's anti-competitive agreements. And so anti-competitive agreements essentially are forbidden unless for some reason they're going to be allowed. Abusive conduct by dominant companies. It's perfectly permissible to be a very big company in the European Union, but you cannot behave in a way which abuses your dominant position in the market. Then you have the body of law which is there to control mergers and acquisitions, and that's a very specific body of law forming competition, a part of competition policy, and you have state aid. So how does that all fit in with competitiveness? That's the next point that I wanted to talk about. Well, you have, I think when you think competitiveness, if I can even say it, you have the Europe 2020 strategy. And I think that that is in everybody's mind here because that's what you were talking about this morning. If you're a competition lawyer, in practice, in truth, you don't think about the European 2020 strategy. But from a policy perspective, competition policy is a key element in that. It's a complement to that. If you read the 2020 strategy paper and you see what the Commission and what the Member States are obliged to do, there aren't specific goals with regard to competition policy. But if you don't have competition policy there and competition policy ensuring that the law is robustly enforced, then it's very difficult to see how the goals that are set out in Europe 2020 can be achieved. And what I think is quite interesting to look at is how competition policy is being used to promote the same goals as the Europe 2020 policy. So if you look at some of the recent ways in which competition policy is being enforced, I think it is quite telling in the sense that the speeches that have been made by the Commissioner recently have focused very much on a kind of defence of competition policy. And the defence is competition policy should be enforced strongly because it has these important goals. And if you look at what we're doing, we are ensuring that the aim in the European Union, for example, of having an open digital world, or where we are ensuring that the goals of the digital economy are met. How are we doing that from a competition policy standpoint? Well, we're doing that by ensuring that the legislative measures which are taken are backed up by cases which enforce competition law. And if you look at some of the recent very important cases in Poland, in Spain, in the Slovak Republic, the telecoms companies are all being forced to take measures to ensure that there is more access to their networks, to ensure that prices come down. If you look at what the Commission is doing in its recent cases to do with standard setting and intellectual property, the aim there is to really ensure that there is innovation, that patents are not being used in a way which blocks companies from being able to reach the market. And so in the last few months, the Commission has opened investigations into a number of mobile companies where the Commission says, you are not giving access to patents. These patents are essential for standards which are in the market. The patents which you are giving access to are at far higher royalty levels than they should be. We're not going to stand for that. So Motorola is being investigated, and now that's Google because it owns the Motorola team. There's various other companies are being investigated from that perspective. And when you look at what the Commission's doing in the financial services sector, the Commission's also focusing on areas where it says we are trying to ensure that there's innovation in the market, that new companies can come in and compete. So we're looking at all sorts of areas. We're looking at credit derivative swaps. We're looking at what has been happening in the area of payment systems. We're looking at what's happening in the area of, well, it's Euribor, LIBOR, and TIBOR, where there has been an argument that there's been manipulation of these rates, and that has fed into derivatives trading, and that has had an impact on an enormous amount of trade. And the Commission is saying, okay, we're taking steps to ensure that where there's a really important impact on the market, we are using competition law to achieve a situation of innovation. So the Commission is using competition law in the way to ensure that competitiveness is encouraged. So what about the European financial crisis? Well, I think when you come to looking at the European financial crisis, the key question is what really has been the effect? And this is where I come to my first slide. So, and this is kind of my career in Brussels, in fact, because the European Coal and Steel Community and the European Economic Community, created by the Treaty of Rome in 1957, I went to Brussels to do a stage with the Commission in 1986, and that was the year of the Single European Act. If you look at the Treaty of Maastricht in 1992, going right through to the Treaty of Lisbon in 2007, I think one of the key questions that you would ask is, well, what's happened to competition policy and competition law in that time? And has the financial crisis resulted in any difference in the law that is applicable? And the truth of the matter is that the provisions on competition policy are entirely unchanged, with the exception of a skirmish, shall we say, which occurred during the negotiation of the Treaty of Lisbon. The rules on competition policy remain as they were. And it's pretty remarkable that after all these years, the rules are flexible enough to cover all the situations that we've had to deal with. So there's no provision to suspend competition law. And at the beginning of the financial crisis, there was a discussion going forward at that time. Would the law be suspended in certain cases? Or what would happen? Would it be enforced? Or would it be flexibly enforced? to take account of the difficulties that were apparent to everyone. Well, at that time, it was quite useful to think about what was said by Commissioner Nellie Kroes, who was in position at the time that the financial crisis began. I started to look at the different commissioners for competition policy to see if there had been many changes. But the interesting point for what we're talking about now is the fact that Nellie Kroes, she said almost immediately in 2008, when people were saying the banks are in a state of great difficulty, how can we enforce competition law? If there's problems in the real economy, how can competition law be applied in the same way? Nellie Kroes said at that time, we will not be soft on competition policy. Competition policy is essential to get through the financial crisis. And that has been echoed very recently by Almunia, who took over from Mrs. Kroes in 2010. And there he says, I hear some voices recommending we should be a bit softer on companies, but I have a completely different opinion. And the Commission and the national competition authorities, when you look at what's happened over the last, whatever number of years from 2008, have been very influenced, I think, by the OECD. And the OECD said very, very quickly, look at what happened in the US. In fact, the competition law in the 30s and 40s was suspended. And when we look at the situation now, we believe that that did not help the situation. So we have to be very tough and we have to continue enforcing the law. We may have to be flexible in some areas, and the key area where that is to be seen is state aid. But in the classic application of competition law, when you're looking at cartels, for example, we want to continue doing what we're doing. And so, when we look at cartels, the key question that we would ask ourselves would be, well, what about crisis cartels? Is it the case that we can have crisis cartels now? We're in a financial crisis. And the truth of the matter is that there is some scope for crisis cartels, but although there's some commission decisions which show that there were crisis cartels and they were allowed, I believe that the state of the jurisprudence of the European Court is such that it would be almost impossible to have a crisis cartel these days. And when you look at the cases that involved the Irish beef situation, when the Irish Beef Federation farmers were in crisis, the European Court said, oh, sorry, this is an agreement which is to counter overproduction, even though it has all sorts of very laudable objectives. That is an agreement which is a by-object infringement of competition law. And it's very hard, I believe now, to think that that would ever be exempted by the European Commission. So crisis cartels, and we have a number of clients who are asking still, do you think that we would be able to get away with a crisis cartel in the current impossible situation? My answer is very unlikely. I think you can see that there has been some impact of the financial crisis, nevertheless, in the area of cartels. To some extent, I thought, first of all, it might be that there are fewer cartel cases now. But in truth, there've only been average of about 5 or 6 cases every year for the last, probably since 1990 or so. And although 2012 there's been 2 cases so far, and 2011 there were only 4 cases, I think that the reality is it's not the financial crisis that's driving the reduction in decisions. It's the standard of review that the European Court or the General Court is requiring the Commission to meet that's slowed down the number of decision making. What you can see is that fines did decrease very significantly between 2010 and 2011. To some extent, it's a function of the reduction of decisions, but it is true that you can see the impact of the financial crisis in the Commission's fining policy. In one sense, because the European Parliament has been influenced by, and some people in the European Commission have been influenced by, arguments that fines which are so high that they go beyond deterrence and they do knock a company out of the market are not fines that are justifiable in the current economic climate. And so the Commission, there have been fewer fines, but there have been a massive increase in a procedure involving a plea by a company of inability to pay. Not all pleas are accepted, but quite a number have been. And one issue, I think, which will be interesting is the extent to which companies simply don't pay fines that are imposed on them. There's been kind of a feeling that a number of companies don't pay and that nothing much happens. And I know that one of the news services in Brussels said the other day that they're going to try and investigate that and see what the pattern is, and say to the Commission, if people are not paying, then that's an unfairness and that action has to be taken. But it's one of these great unknowns. So I'm flipping over these, and I'm going to stop, in fact, because I want to leave the area of mergers for Arianna to touch on as well. But what I want to say in conclusion is a couple of things. I think that when you look at the financial crisis, what you see is a major change when it comes to the enforcement of state aid. What you see when you're looking at cartels is quite surprising. If I had been asked, I was asked in 2008 to predict how the rules would be enforced, I thought that there would be some more flexibility. I thought there would be a reduction of fines in a quite noteworthy sense. And I don't see that in the way that I expected. Nevertheless, there has been some impact, I believe, in the area of cartel policy, particularly in the amounts of fines that have been proposed, and to some extent, as I say, in the Commission's approach to accepting pleas of inability to pay. But when you come to mergers, my conclusion is it's pretty much business as usual. There was a view that maybe there would be a whole-scale change in the Commission's merger policy and there would no longer really be proper review of merger cases. I don't think that that has come about. What I do think is that the financial crisis has interacted with a change in personnel in competition policy, and what we've seen is a new commissioner and a new director general in DG Competition. They are economists by background with a very good knowledge of detailed competition law. But their whole-scale concern, I think, because of where they come from and what we see in the economic environment, is to focus on issues which affect the structure of the market. So when we look at what's happening in competition policy at the moment, we see that cartels are pursued if they are really pretty important for consumers. We see that the Commission is focusing much more in areas which have ramifications in the market, which are very key. The Commission is not focusing on distribution agreements between companies, with the possible exception of the food sector, which I can talk about if anybody wants to ask. And so what we see also is this very proactive side of the Commission. It's coming forward and it's saying in its website and in many speeches, look at how important competition policy is in the financial crisis in order to ensure that the EU is competitive. We have to have strong enforcement of competition policy, because if not, the the economy is not going to come out of the difficulties that it currently is. So my conclusion is, for a lot of what I've talked about today, if you say financial crisis, it's crisis, what crisis? There's been very little change. Thank you.
Thank you very much. Well, I have to say, I couldn't agree more with what Jackie has said so far, and what I'm going to look at in my presentation is basically looking into how actually the Commission has deployed its instruments of competition policy in a time of crisis. Now, it struck me when I was when the financial crisis, the subprime mortgages crisis in the US struck in 2007, that these were challenging times indeed for competition law and competition policy. I was shocked, quite frankly, when the Lloyds HBOS merger was basically waved through by Gordon Brown and Mandelson, and basically the UK government got in the way. And I was dismayed, actually. I said, that could have been such a good example of competition policy, merger review, getting in the way and actually trying to do something constructive. Because there is an instability in the financial sector. However, the impact that waving through a merger of that magnitude could have for the future of this market is, to be honest, quite significant. Not to make a massive understatement of the whole thing. And I just thought, oh my goodness gracious me, what's going to happen now? And in my presentation, what I'm going to look at, first of all, briefly at the timeline of the crisis and what has actually meant for the position of the European Commission. And then we're going to look at in more detail at what happened for specific instruments of competition policy, briefly about Article 101, and I'm going to say something more about crisis cartels, because the Irish beef industry, and by the way, I'm a vegetarian, so I don't have any interests in it. It's a bit of a hobby horse of mine. And then I'm going to concentrate more on state aids and merger policy. First of all, the timeline of the crisis. First of all, I would like to tell you one thing that really struck me. So I've never been a fan of Neelie Kroes. However, in 2008, just after the meeting of the economic and financial ministers, the ECOFIN meeting in October of 2008, she had a very powerful speech in front of the European Parliament, and she said, competition law is part of the solution, is not part of the problem. And I think that was something that really encapsulated the attitude of the Commission as it was about to change in 2008 after ECOFIN. Now, as you all know, the crisis unfolded from the crack of the subprime mortgages industry and the cartelarization in the US market, and it all started unfolding, I remember, in September 2007, and it was tragic. Really, really tragic. And I was in the States last year. I visited Detroit, and I can tell you the ravages is too difficult to beckon. Anyway, that all started in 2007, and I remember it struck me that the Commission adopted a very strangely passive, anodyne approach to the crisis. It was more of a wait and see position as opposed to actually diving in and being proactive to it. It was a witness to the action of the member states, and it's not perhaps the case that, for instance, HBOS and Lloyds happened just around that time. Northern Rock happened at that time. The Commission was on a wait-and-see approach. It was as if, I suppose, a lot is to do with realpolitik. A lot is to do with the fact that there was a clear instability in a key sector of the economy, the financial sector, so, payments and all sorts of things. That was a real risk, not just for the banking and financial sector, but for the real economy at large. So probably time was of essence, and therefore the Commission saw it may be fitter to its own agenda, as well as for the interests of the member states, to take this wait-and-see approach. Nonetheless, taking this approach was absolutely full of risks, because obviously the risk is that you might have the emergence of national champions, just to tell you one. You might have protectionist torpedoes. In other words, you might actually allow, by not taking any action at all, member states to shape the economy, the structure of individual markets, so as to foreclose those markets to pressures from outside. ECOFIN was a real watershed, because in October 2008, more than a year after, they realized that whatever emergency was still unfolding, and more to the point, the shockwaves of the real economy were really, really significant. They were becoming to be visible, and incredibly so. So the ECOFIN meeting in October recognized that this was a systemic crisis. It was no longer a crisis limited to the banking and financial sector, but it was spreading to what we call the real economy, i.e. real industry, real economic activities, which were not just about trading derivatives on the stock market. And this actually had a very, very strong impact on the role of the Commission. The Commission understood that it could no longer sit on the sidelines. He had to dive in and get involved. And the way, and Jackie with this is very right in saying, crisis, what crisis? The Commission relied on the instruments that it had at its own disposals. So to a degree, even though very limited, Article 101, but more to the point, merger control and state aids. Because these were the tools that allowed the Commission to intervene more and more on markets with a view to addressing the shockwaves of the financial crisis for the real economy. Now, one thing that, starting from state aids, the systemic crisis meant intervention on two different levels. Intervention more direct in the banking and financial sector, as well as intervention in the real economy. What was surprising, especially after ECOFIN, was that the Commission sought to rely, in terms of state aids, on a legal basis for its own action in terms of supervision of financial intervention in the economy by member states, which had not used before. Article 107, paragraph 3, in fact, says that among the grounds on which the Commission can authorize aid is when member states seek to intervene in the economy with a view to addressing a serious disturbance in their own economy. And the Commission, in its banking communication, for instance, which was released shortly after ECOFIN in November 2008, said it very clearly. This is a systemic crisis. If this is not a serious disturbance in the member states' economy, you tell me what it is, because I don't know. So the Commission took for granted that this threshold had been met. However, this also meant a far wider flexibility for the Commission in actually overseeing the aid that member states could grant. The Commission sought to dive in the supervision of aid in a far quicker, far more proactive way than it had done in the past. Now, this choice was criticized because, they said, okay, this is uncharted territory, Article 107, paragraph 3 had never been used. Why doesn't the Commission not choose whatever it has at its disposal already? However, from a realistic point of view, probably this was the best possible option for the Commission as far as state aids were concerned. Now, people might not be familiar very much with the discipline of state aids. Now, state aids are an area that the treaty deals with in the context of competition policy, because there is a recognition that allowing member states in general should not intervene in the economic affairs within their own jurisdictions. However, and therefore the treaty in principle prohibits forms of financial intervention on the part of the member states in whatever form that might have a distortive effect on competition or might threaten to have such an effect. Now, state aids is any form of financial assistance in whatever form that is selective. In other words, it is targeted and affects only certain subjects. And it can result in these distortions of competition or in a threat to competition, because the recipients of this aid basically are in a position of competitive advantage vis-a-vis others that are not receiving the same kind of assistance. Now, state aid, however, can be authorized the member states that wish to intervene in the economy, first of all, there are some forms of financial assistance that are allowed under the treaty. For instance, anything that, now I'm thinking about my country, assistance that is targeted at addressing the consequences of natural disasters. That is allowed. You know, in my country, I don't know if people probably know, there has been a terrible earthquake, the second in just a few weeks. So, you know, I suppose that if the Italian states intervene, as it probably will, that will be waved through, no problem at all. However, any other form of financial assistance which is not identified by Article 107, paragraph 2, must be authorized by the Commission. Member states must submit an application for authorization to the Commission, and until such time as the Commission has said that is fine, because this is aid that has no distortive effect on competition or the effect is not appreciable, then the Member states must abstain from diving in, basically, injecting these resources into the economy. Now, as I said to you, state aid is something that in principle is prohibited. And it was very much part of the Lisbon strategy, so 2000 onward, that there should be an agenda for better aid. Aid which was better targeted. First of all, aid should be in principle very limited. And whatever aid is given must be very well targeted, must be appropriate, must be necessary, and must be proportionate. This means that any financial assistance must respond specifically to a specifically identified, precisely identified need. It must be necessary and proportionate in the sense that it must be only limited to what is really required to address a specific mischief. This means that it must be limited in time. There must be a significant own contribution to the aid on the part of the aid recipient. And in principle, there must be a very clear plan that must explain why that aid is necessary and how it will be put to use. Now, the first and perhaps major outcome of the Lisbon strategy were the rescue and restructuring guidelines. Now, the reason why I'm mentioning these is that these were those guidelines that became really important with the financial crisis. Now, the rescue and restructure guidelines, R&R guidelines, were enacted by the European Commission to give guidance as to what aid targeted at rescuing or restructuring firms in difficulty, economic difficulty, is likely to authorize. Now, one thing that really is important in the context of the guidelines is that, first of all, the firms must be in difficulty, preferably not because they've been reckless in managing their own affairs, but because of the external circumstances. The other thing is that aid must be, like I said, appropriate, must be necessary in the sense that more than 6 months is clearly not allowed. Aid must be given to a firm only once every 10 years. And more to the point, there is a very clear distinction between aid aimed at rescuing a firm in difficulty, in other words, at taking it out of the danger zone, and aid that instead allows the firm to have some breathing space to restructure its own affairs. In that case, the Commission insists that the firm that receives the aid would submit to it a plan of restructuring, and this plan of restructuring must be incredibly detailed. Now, the other thing that I would like to emphasize in the context of the guidelines is that the recipient of the aid must give a substantial own contribution to the aid. In other words, it's not something that the state gives away for free. The recipient must also do their own homework. And the R&R guidelines say that this contribution must be in the region of 50%, which is pretty significant if you think about it. However, these were incredibly successful because the R&R guidelines really tapped into what the Commission thinks is appropriate, necessary and proportionate. They also have to be seen in the wider context of the Commission really being quite good at calibrating state aid to the needs of the economy. For instance, after Lisbon, there were guidelines on de minimis aid. For instance, some aid is not considered to be relevant for the treaty provisions because its magnitude vis-à-vis the overall economy is clearly too limited. You know, it's the application of the general maxim minima not curat praeter. Then there is the other issue of there is the other issue that the Council has the power to identify through a regulation which is adopted in consultation with the Parliament, forms of aid that are in general authorised. So, for instance, aid which is targeted at particular economic sectors, for instance, aid for culture and so on and so forth. And the Commission itself can grant what we call the block exemption regulations. In other words, it can identify categories of aid and say, these are exempt from the obligation of notification. So you have to see the R&R guidelines in the context of a flexible strategy with a view to having better aid. Now, you can see for yourselves that the rescue and restructuring guidelines were really the prime candidate, the prime tool that in principle could be used to tackle the effects of the financial crisis, especially after the financial crisis became a systemic crisis. Now, 2008, like I said to you, was the real watershed moment. And after 2000, and in November, there was the banking communication, followed in 2009 by what we call the temporary framework for aid, which is instead targeted at the real economy. So it's not about banks, it's about all firms in difficulty, not because they've been reckless, like many banks, I have to say, and I don't apologize for my ideas about this. But because they are sound but illiquid. In other words, they are affected by the credit squeeze. Now, in respect to the banking communication, the banking communication was published in November 2008, and its goal was to use the existing tools of state aid with a view to responding to the financial crisis in a very flexible way, while at the same time respecting the basic principles of the better regulation agenda that were part of the rescue and restructuring guidelines. So if you like, this is a derogation from the R&R guidelines applied to banks. Now, it is in many ways a derogation from the R&R. However, it embodies a lot of the general principles of the better aid agenda. For instance, the Commission takes the view that it is general schemes, in other words, aid which is open to everybody that is eligible for it, that it is likely to approve. Also, it identified as troubled financial entities, those financial entities that have been affected by the crisis through the circumstances and not through reckless practices. The Commission says it clearly. If you've been reckless, it's your own bloody fault, and therefore you cannot benefit from the banking communication principles. Aid can be given in a limited number of forms, mainly by the granting of loans that are cheap loans, so loans at subsidized rates, or guarantees. However, these guarantees, the Commission is very careful. It says these guarantees are only there to back up certain specific types of liabilities. For instance, retail savings. Obviously, there is a clear public interest concern there. The other point is that, again, assistance must be temporary. However, under the banking communication, the Commission says the banks, it can be for longer than 6 months, as you will have seen in practice. And more to the point, it derogates from the once in 10 years rule, which is typical of the R&R guidelines. The other thing I would like to stress is that, again, the Commission, in accordance with the Better Aid agenda, says that these general schemes must be open to all the eligible parties and must be applicable, an aid must be granted according to these general schemes, according to objective, transparent and non-discriminatory conditions. And also, again, there is an obligation to give a substantial own contribution. It's not 50%, it's actually 90%. It's not 50%, it's 10% actually. So aid can be given for up to 90% of the liabilities, for instance, that the bank has got to cover, which is in and of itself another derogation from the R&R. More to the point, the Commission allows states to impose on the recipients of aid commitments, for instance, in relation to commercial practices. This was the case, for instance, with the Lloyds Banking Group. Aid was, the Commission waved through the Impair Asset Scheme that the UK government had devised, subject to an obligation that the recipients of aid would change their business practices. Also, there are a number of very important, significant structural commitments in this area. For instance, many aid recipients have been made let go of a number of quite lucrative businesses in certain areas. For instance, the divestiture of key branches. That was one of the conditions attached to the aid to Fortis. So that was quite aid to Dexia, which is a Luxembourgese bank. And again, any loan or liabilities, even though they are cheap loans, again, there must be an adequate remuneration for them. In other words, again, the Commission stresses is not a free-for-all. It is not a free-for-all. Even though they are not commercial rates, there must be some form of remuneration. So this is quite, the banking communication in 2008 was really, really important because it provided a lifeline to banks that were actually in systemic problems, that were experiencing systemic instability. Now, another thing that I wanted to say is that this also allowed member states to intervene pretty quickly, because that again was another concern. Time was of essence. And having the banking communication there in place allowed the member states pretty much to dive in with a certain flexibility that allowed them to respond to the challenges of the moment. However, this was not the end of the story, because like I said, the crisis was and has been systemic. It has affected the whole of the economy, not just the banks, because the credit squeeze has been a reality for major industries. This is why the Commission in 2009 enacted a temporary framework. Now, the temporary framework, again, a set of guidelines allowing member states to grant aid to real industries, to real firms that manufacture stuff, they do not trade in derivatives. Now, the good thing about this was that, obviously, again, it provided a safe harbor. It did so by relying on on the better aid agenda. What the Commission did is that, first of all, it allowed member states to benefit more widely from the safe harbor provisions that it had already enacted with the de minimis regulation and also with the block exemption regulations. And also, it gave member states the possibility to extend their ability to intervene in the economy via financial resources in a more flexible way. Now, again, what is really important is the definition of the recipient. The recipient is a sound but illiquid firm, a firm that cannot get a credit line because banks do not lend. And member states can give aid either in the form of lump sum loans or in the form of subsidized loans or in guarantees. Again, one thing is that the criteria, again, derogation from the R&R, so more lenient criteria. For instance, there are no limits as to the total wage bill of the recipient, just to tell you one. Again, the Commission prefers general schemes as opposed to individual assistance. And there are the temporary limits for the granting of this type of aid are more flexible. So again, it can go for longer than 6 months, and even though the Commission in general wants to know pretty well what they're going to do with this aid, and more to the point, they want a justification as to why this aid will bring the firm to long-term viability, they're not that exacting when it comes to a restructuring plan, for instance. Another thing is that, again, they insist on the own contribution, which is now 20%. Now, you can see that they're a bit more tight than with banks, which is a bit naff, and that has created issues when they go and negotiate these forms of aid. However, it is nonetheless quite a generous derogation from the R&R. One problem with this is that this type of aid does not have to be notified, and that obviously raises all sorts of questions for legal certainty, because basically you receive aid and then you don't really know whether or not the Commission will take it back or allow it, which is not the best. And again, another area in which the Commission has intervened to deploy its competition policy tools is the area of merger policy. Because, okay, another aspect of the crisis was the tendency for industries to restructure and sometimes to consolidate in ways that could be anti-competitive because there is an increase on concentration. Again, in the two periods of the crisis, 2007, 2008, again, the Commission also, as far as mergers were concerned, sat on the sidelines. So, you know, Lloyds and HBOS and so on and so forth. And obviously, this could have quite a lot of dangers: national champions, market foreclosures, and so on and so forth. After ECOFIN, the Commission realized that it had to get tough and it had to dive in, also in terms of merger controls. So, for instance, what they were keen to stress is that they would not change their tack. They would not take a soft approach to merger policy. They would use whatever tools they have at their disposal, just more flexibly, more responsively, to deal with the challenges on the ground. For instance, Philip Lowe, which was at the time Director General, said we can use the failing firm defense. In other words, we can justify mergers on the ground that the acquired firm would have exited the market anyway, because it was in such a dire strait financially and economically that it was just a matter of time. They endeavored to be quick, even quicker than they are, in clearing the mergers. For instance, Fortis, BNP Paribas, they were able to give approval almost overnight, which was pretty impressive. And they were quite exacting, yet at the same, flexible and quick when it comes to testing divestiture obligations, merger remedies, merger commitments. One key case which I quite liked and I thought it was quite helpful is the case of Lufthansa and Austrian Airlines. Austrian Airlines was on the edge of bankruptcy. Lufthansa bought it over. And however, the problem was that there was a lot of slot congestion. You're probably going to talk about this. There was a lot of slot congestion because obviously that allowed Lufthansa to get a lot of market power on key slots between Frankfurt and Vienna and so on and so forth. So one obligation that the Commission imposed on the parties was for Lufthansa to let go of a number of these slots in favor of a new competitor or new competitors on these particular routes. And these remedies were proposed and cleared within a week, which, you know, is pretty good going. But it demonstrates that the Commission was pretty canny. Once it got its act together, you know, it took time, you know, they're a bit like a diesel engine. It took time for them to warm up. But once they got going, they used merger policy pretty flexibly. And what to leave? Is it all well? Not all is well, because as Jackie has mentioned, it is no longer acceptable to agree our way out of the crisis. The Commission used state aids and merger policy to the full. When it comes to crisis cartels, no way, Jose. Crisis cartels are just out of the window. They're out of the window because since 2001, we've embraced the gospel of the fight against cartels. So it is no longer acceptable to agree your way out of a crisis. And the Irish beef market cartel, the BIDS agreement, that was a very good example. It went as far as the European Court of Justice on a preliminary reference. The Court of Justice basically said to the Irish Supreme Court, I'm really sorry, this is a restriction of competition by object and it is prohibited. It is market partitioning and foreclosing the market of the worst kind. We are not going to accept it. No matter how laudable the goals of the parties are, this is not acceptable anymore. So what are my conclusions? How does competition law come out of the economic crisis, both the financial crisis and the crisis of the real economy? I'd say still in one piece, but bruised and battered. Bruised and battered because, first of all, I think that the Commission, like I said to you, I was probably was a bit of dark humor, but it took a long time for the Commission to get its act together. The problem is that the initial impasse came at a really big costs, because it really allowed member states. Of course, member states had to deal with the crisis on the ground. However, the outcome could have been really damaging, really negative when it came to national champions and the creation of barriers to national markets. So I think that that initial impasse tells you a lot about the Commission being in some way a bit constrained by the realpolitik of the crisis in many ways. But once the Commission got going, I think they managed to use, and I like this expression, smart pragmatism. They managed to use whatever instruments they had at their disposal in a very flexible and responsive way. So state aid, welcome to a brave new world. I have to say that the better aid agenda was really used to the full in these circumstances in a very realistic and flexible way. Merger control, They relied on merger control in a really they used these tools to the full, with a view to tackling the consequences of the crisis. However, I have to say, and this is why I say they're bruised and battered, they haven't dealt with all the challenges yet. And there is a lot to be said that probably we should start being worried. Because, for instance, the future is unwritten, I have to say. Because what about these too big to fail scenarios? These big concentrated markets, like the banking market is incredibly concentrated throughout Europe. And that is going to come at a cost. It's going to hit us at some point. And until such time as a viable competitor, a viable purchaser emerges, there's not very much we can do. But the Commission needs to start thinking quite quickly about it. And obviously, what about foreclosure issues? The aviation industry is rife with these alliances and these big mergers and so on and so forth. Okay, some of them were blocked. For instance, Jackie mentioned Ryanair and Aer Lingus. But what about the others? That's why I'm saying all is well. Well, something in competition law is clearly well, and they managed in the end. They managed, all things considered, to respond to the challenges of the crisis in quite a creative and a quite effective way. However, to say that all is 100% well, I think is probably pushing it, because it is the future that I'm worried about. Thank you very much.
My name is Annette Bongard. I've got a question which I guess is not really a question, it's a comment and applicable to everybody, sorry. The question or comment is the following. You emphasized a lot and rightly the importance of competition policy for creating a level playing field for economic growth, and as well the impact of the financial and the economic crisis. I would add the sovereign debt crisis, which, if anything, raised the need for economic growth. Now, the challenge in reality is not only growth, but it's sustainable growth. Knowing that, we recently did a review of the literature, and we looked at whether there were any trade-offs between competition policy and environmental protection. Mm-hmm. I did this with a colleague who's not here, João Gata. And what we saw in the literature was that, in theory, basically there were very few sources of conflict, and where they existed, that in practice they were balanced out by the Commission, that had a proportionality test, especially in the case of state aids, which are obviously negative taxes. A second issue that we now want to address in a bit more profound way is obviously the instrument that is being used at the moment, the emissions trading system, which is a market instrument, which means it prices environmental damage, and which means that it works via the price signal, and to work well it needs a functioning market to penalize firms. And here obviously at the outset you have a synergy, but much depends on how you create that market. So it depends on the rules that are being created, and I understand there is an effort to set up a common auctioning platform, for instance, a common registry, and so on. So obviously, how the secondary market is going to work will be crucial. A question or a comment I have, or more question I have on the last part, in the case of transport, obviously you have the aspect of liberalization, obviously you have the aspect of regulation, but what about the sustainability?
Yes, I think about emission trading systems. I don't know, this is not my area of expertise, but my understanding is that initially people get certain rights. And once they have achieved these rights, you can trade these rights. Now, in principle, you could say if people get certain rights, this is an aim.
As it happens, yes, because it's a subsidy.
Yes.
And the Commission's looked at those as aids.
Yeah. Yes, and so this is an issue that perhaps we should consider whether this is problematic or not. And you know the outcome of
I
this
mean,
review.
the Commission has looked at that, and I believe that the Commission has said that that's okay, because the interaction of environmental policy and competition policy comes to a head, but there are specific state aid guidelines for the environment, and I'm not an expert, but I believe that the Commission has looked at the emissions trading legislation and the emissions rights that have been granted, the permits that have been granted, and they've considered that to be compatible. But the question I think that you're asking then is whether in the transport area sustainable development is considered in the policy making. So I think that's probably separate.
And I know in the transport area there's a big discussion going on right now about the air transport sector, which was not until recently covered by the emissions trading system.
Yeah.
And Europe has been very strict in continuing to push for this, but I know there's big resistance internationally. And
not only.
And the US is very unhappy.
But as I said, I think my general reaction would be is that competition policy needs to be applied in every sector, business as usual, as mentioned before. However, one needs to always take account of the particular characteristics of a certain sector. And that's what I've tried to illustrate with the examples. You cannot just go ahead and take the articles in the treaty and say this is the end result. You also have to look at the specifics of the sector, recently liberalized, particularly affected, I would say, by emissions, which is important for transport, and I think we would start from that perspective.
Obviously, this would take you further, right? Because the emissions, if you look at different transport systems, obviously the environmental impacts are very different. And as yet that is not reflected.
If I can just start, if I can just add on this, I mean, you're right. There is when you go and have a look at the way in which competition policy interacts with environmental protection, there is a balancing exercise that the Commission has carried out across the piece in a number of cases. What I would suggest is that, without doing the Commission too many favours, because I have very little time for them, but on this on this I would like to say that each case and each economic sector, as you said, is looked at in its own terms and in its own merits. So what I would suggest is to be mildly open, or if not mildly optimistic, to a consideration of sustainability whenever these schemes are actually elaborated and approved. The issue is that, obviously, is how you go into a secondary market, and that is an entirely different issue, which I'm not sure that the Commission can actually go and sort out directly, because you have to give companies the right signals in terms of open markets, because once you give the company the right signal, the market is open, then companies will dive in and will take advantage of the opportunity. And obviously, beyond creating that level playing field through the emissions trading schemes, the way in which it's been devised, that then becomes a realm of business. It's no longer the realm of policy. And this is not just about the environmental protection and the trading of emissions, but it's about a number of innovative sectors. For instance, I'm looking into electricity liberalization and the rollout of the smart grids, and that is another area in which there will be business having to roll out the grid. Obviously, it is the concern of the Commission to make sure that incumbents don't fiddle with wholesale market, but then the secondary market is pretty much a realm of business. I don't know if that helps your concern, but I would, like I said, I would encourage you to keep an open mind on this, because, like I said, it will then be an issue also of creating right incentives.
Can I just add something?
Sorry,
no, I was just going to say that if you look at the treaty, it is a requirement of the treaty to take account of sustainable development in every policy, in every piece of legislation, in every decision that the Commission adopts. So you can always make an argument that whatever it is that the Commission is doing, they should take adequate account of environmental concerns and the needs of sustainable development. On the other hand, you do have a balancing act in many of the areas of competition policy. And it's certainly true that I think coming out of the transport sector, I think there's one decision that I'm aware of where the Commission said, we think this is kind of anti-competitive. It was an agreement between, I think, it was quite a long time ago, I think it was washing machine manufacturers.
Yes.
CISID.
Yeah.
And the Commission said, well, actually, we think what you're doing is promulgating standards. They really are very, very, very useful from an environmental perspective. And so we'll put competition concerns to one side and we'll approve this on the basis of the environmental benefits. In other cases, I think that the analysis has been much more nuanced. But it's certainly the case, for example, listening to you talk, I kind of remembered when the emissions trading legislation was being adopted, we were asked by one particular industrial sector to make arguments, which was that competition policy and competition concerns were not being adequately taken into account by the environmental policymakers drawing up that legislation. And we did that, and the legislation, actually, the final legislation takes account of the arguments that we and others were making. So in practice, the two come head to head very often.
Thank you. Jim McLean, solicitor in Edinburgh, not from Manston. But I'd like to just ask a question in the capacity of consumer, because all three speakers have said that in the end, this law is supposed to benefit consumers. And my point, I don't know whether it's a question so much, is really aimed at Mr. Dearsh. Britain was one of the first countries to liberalise its railway system and open it up. You will look very hard in Britain to find a consumer who is pleased that that has happened and with the results of it. There are lessons to be learned from that, is all I would say.
It's not my job here to defend the liberalization of the railway sector or the liberalization of whatever sector. I just want to make a general point that, okay, liberalization in principle, it should be positive for consumers in terms of better quality and lower prices. However, it doesn't always work out that way. However, since I'm here in the chair as representing competition policy, what I'm saying is that if the sector has been liberalized, then you would agree with me that if that's the case, it would be best to make sure that competition in that sector is fair and hard. And that would be better than a situation where a sector is liberalized and competition policy is not active, because then you get even more serious problems. I would actually argue that competition, the more you have problems in a sector, according to consumers, the more important it is that competition policy is active in that sector.
I wouldn't disagree with that, but it is important that it be accompanied with transparency and with open, easy contracts for consumers.
Maybe I could just say the three of us, I think, have argued in favour of having an actively enforced competition policy, but none of us have said that competition policy alone will do the job.
Yes, exactly. And if I can just say so, I mean, since you mentioned the railway sector, I think the issue about the railway industry is the interplay between a wholesale and a retail market, and the choice that was made under the Conservative government that liberalise the sector was in the sense of having a single owner for the grid and then different companies running the retail services, i.e. the actual trains, and then there was a rolling system of bidding for the various routes. Now, you're right, the issue is transparency, the issue is making sure that the bidding system works in such a way that the better companies are chosen, and more to the point, that there is a system whereby wholesale access to the grid is actually granted granted according to fair, reasonable and non-discriminatory discriminatory requirements and terms, which seems to be the case to me. That is actually where the problem lies, because if there is one thing that I never got my head around it, and by golly I've tried, is to see how National Rail actually determines the fees for access to the grid. It's one of the things that is most difficult. And that, I think, affect, because obviously these are fees that are so important because they are a component of the actual price that one pays on the ticket. And so I think that you're right, the issue is not so much about making the choice of liberalizing, it's actually how you roll out the liberalization itself. Jackie is right, competition policy does not provide all the answers. You need to have free competition, but you also need to take a position at the very start when you choose the liberalization route that you wish to take that actually grants that transparency. I think that is the key issue, and I think you're absolutely right.
How to buy a ticket that will take you from A to B through C without you having to get off the train
At D, yeah, exactly, maybe.
No, well, I can tell you, because I travel a lot, that it is impossible sitting in Brussels to find information about making a journey in Great Britain, even though it seems to be a fairly usual route. It's just impossible to get the information and plan it.
Yeah, I'm Claudio Rarelli from the University of Exeter. A question for Jacquelyn MacLennan. I wonder what you make of the well-known fact that the number of mergers that were actually blocked over the last 20 years by the European Commission is a small fraction of the total 4,200. On the one hand, one could say it's proof that the Commission is operating a permissive policy. So it's very small compared to what the large firms dictate. On the other, there is a school of thought that points to what we don't see, deterrence, cases withdrawn. Obviously, no empirical research can be done on the two stages of the merger procedure. And these people conclude that actually the Commission has pursued a kind of activist policy. So they have a view of what the market should be, and they have a view of mergers. They have a kind of their own economic orthodoxy. Is this? Would you like to endorse one of the other propositions, permissive versus activist?
Yeah, I actually have a slide, I don't know if there are copies given, but it doesn't matter, which shows how many merger applications there have been over the last, I think what the slide is from 2006. And you can see how there's, the high point I think was 2007 probably, when there was about 400 a year, and then it's come right down. Every year it's been coming down. It went up a bit in 2010, came down again in 2011, and I presume this year it's going to come right down. Now that's the number of notifications, so those are the mergers with a community dimension. It is the case that not every merger has a community dimension. And as an aside, I just would support what you were saying, where a merger does not have a community dimension, a national competition authority therefore has the competence to review that merger. You see more industrial policy, national political issues coming into that assessment. And I think you see that in the airline industry, and you've got Alitalia. If you compare what happened with Alitalia with what happened with Olympus Aegean, very different decisions. If you compare the UK decision with HBOS with what probably would have happened if it had gone to the European Commission, would have been different. But in any event, so you've got a drop in the number of merger notifications. As you said, you don't have any change in the number of decisions being blocked. The Commission really does not like to block a merger. A, because most mergers have a global dimension, and if the Commission's going to block it, what are the US authorities deciding to do? What's going to happen in China? Have the Japanese got a role to play? It gets horribly complicated. So there are very, very few. I think 3 mergers have been blocked in the last few years, and the latest one is the New York Stock Exchange Deutsche Börse. However, as you said, there's a school of thought that says what you see is not what you get, because what's really happening is all under the surface. And what's really happening is not the decisions which are being taken to block or not block, it's what are the decisions not to block really about? And in fact, what's happening is that even where a merger goes to a phase 2 decision, so you've got a statement of objections, you've got a fuller decision, you will, in some cases, but there's still quite a small number of cases when you look at the numbers, have the Commission saying, we will approve this merger subject to remedies, subject to commitments. And these are normally what we call structural rather than behavioural remedies. In other words, you can do this, but you've got to sell off this whole sector of your business. And then you can be a merged entity, and that's fine. But in truth, what you see is not even what you get there, because in reality, when you are doing a merger notification, when you're advising a company right at the beginning, what are the prospects of success of this deal going through? You look at the markets, you look at the different areas of concentration and market share, the other competitors, and you say, you know what? Sectors 1, 2, and 3 of your business, there's probably no problem. But this, highly, you know, you're coming down from a 3 to 2 situation. There's only 2 competitors in the market. The Commission is never going to allow you to stay in that market in the way you are just now. So if you want this to go through smoothly, think about what divestitures you're prepared to make and put that on the table. And that, in practice, is what happens. So you don't even go to a phase 2 merger decision. Because what you do is you offer what would be an eventual remedy, and you do a deal with the Commission there, and that's how it goes through in 25 days.
Yeah, if I can just add something. Actually, you can. There has been some empirical work done on merger procedure. I did some studies on merger procedures. Actually, you would be surprised. The truth of the matter is that merger procedures, either in Europe or in other jurisdictions, because the same is true. And last year, I had the good fortune of meeting a big merger litigator that works in the States and does a lot of work in the FTC. It's a heavily negotiated area. As Jackie has explained, these people go in and make a deal. The Commission, for instance, when you make a notification, actually, the notification is already about 70% of the deal already done.
It's already
because
you
already had informal contacts with the Commission. The Commission will tell you how to notify and what to notify, because it will identify the core issues in your concentration, and then will tell you, okay, from this moment the clock starts to tick. And you have triangular meetings with stakeholders, you have state of play meetings, all the way at key stages, exactly for that purpose, to negotiate merger remedies. And what is key is time. Time is of essence throughout phase 1 and phase 2. So actually, I am prepared. Actually, I think that the second viewpoint that you expound is probably the most correct, because these negotiations are actually key. And it's not about just the European Commission. It's about, the merger system in the States works exactly in the same way. And this is very much the nature of the beast. It's just the way these things go, because obviously time is of essence and you need clearing straight off.
And if you have a Chinese dimension, you can just expect the whole thing to be screwed up for quite a while.
Absolutely. Oh yeah. Amen.
Using a technical term.
Yeah, of course, yeah.
Okay, David, and then...
Sorry, I've got the mic already. I'll abuse my position. I have a question about then the network of national competition authorities, right, on which the EU, the Commission sits, or is a member, is involved. Because I would think that the important dimension of this, looking to the future of EU competition policy and competition policy in Europe, is trying to move towards maybe not harmonization of understanding of EU competition law, but also understanding of desirable national competition law and competition policy. And indeed, I've seen studies that have looked as well at this network of European competition authorities, and how their joint efforts have helped, particularly the weaker authorities within Europe. Some authorities are quite new; they don't have many resources compared to, say, the Kartellamt in Germany or in Britain, their position in relation to government is relatively weak. Also, the French Competition Authority, which is very weak until relatively recently, but has started flexing its muscles on a series of cases. So maybe if you could all, particularly Jacquelyn and Arianna, discuss what you know about that network of European competition authorities.
Absolutely. Well, the ECN is one of these things that, I mean, you have to bear in mind that cooperation among competition authorities has always taken place since the very early days. The truth of the matter was that at the beginning there was very little in the way of competition culture, and that was obviously reflected in the institutional framework across Europe. So there has been a flourishing of competition authorities only from the 1990s, because the first competition authority, which even precedes the Commission, was the Bundeskartellamt, because the Bundeskartellamt was created as a condition to the Marshall Plan in 1951. Now, and because, you know, it was something that was bestowed upon the Germans by the Americans as a condition. Now, the ECN had a boost with the modernization reforms which were introduced in 2003. And I mean, it was a very canny and very pragmatic choice of the European Commission. The Commission was boxed in a corner of having so much work to deal with that basically had to, and also at the same time, they realized that they had to let go of the monopoly position, of the hegemonic position in competition policy that they had acquired. And so they encouraged the competition authorities within the member states to take a far more proactive stance as far as competition enforcement was concerned. The European Competition Network, however, at the same time, there was a very big political problem there, because as you rightly point out, some competition authorities were quite up and running. They could actually take charge of their own affairs, like the Germans, the British, even the Italians. And at that stage already, because the competition authority was created in Italy in 1990, so they already had like good 12 years of work under their belt by the time the reforms came round. Other states were far weaker. I mean, think about we're talking about 2003, 2004, so we're going toward the Europe of the 25. So they were faced with accession and all these challenges. So they created this European Competition Network, which actually is something which is very informal. It hasn't got any institutional status. It's just a network of cooperation. It's soft cooperation across the piece. The only reality is that obviously the Commission is in a hegemonic position of the network as well. The Commission can relieve of jurisdiction the national competition authorities of individual cases by starting its own cases, and obviously that is very much in keeping with the principle of supremacy. You have parallel and joint jurisdiction as far as cases having a transnational aspect are concerned. Obviously, the court has said that this jurisdiction on the part of the competition authorities in the member states is contingent upon the Commission taking action. In other words, the Commission is the key enforcer, and it can relieve jurisdiction, can relieve the competition authorities in the member states of their own jurisdiction as regards individual cases. At the core of the network is this system of circulation of information and of cooperation, so they can assist each other with individual investigation. That has created massive problems, because if on the one hand it's true that there is a push toward harmonization, there is also another reality, which is national autonomy. So member states can decide the procedures that these competition authorities can deploy. So for instance, rights of defense, contrary to what the Commission says, there is no such thing as a level playing field there. And that is going to create a lot of litigation whenever the European Union becomes party to the European Convention on Human Rights. Just to tell you one challenge that this network faces. From a caseload point of view, it has proven quite effective, because obviously it has allowed member states to take charge of their own caseload on the basis of the principle of subsidiarity, while at the same time relying on a very effective safety net. So it has had a lot of very positive consequences, but it also has and continues to have a lot of very significant and serious drawbacks. And one thing that I think is going to be a challenge that the competition authorities are facing every day is the continued effectiveness of leniency programs, because obviously when you have a case started on the basis of leniency, the notice on cooperation states that other member states, when they receive information on new cases, they cannot start their own investigation. However, if they hear it from a different channel, they can. Now, are you telling me that these competition officials can suffer from what we call selective amnesia? Again, this is just one challenge. Just to tell you, one challenge will be, another challenge would be to keep the leniency programs up and running throughout the union. The bottom line, which in the end of the day comes down to, European Competition Network was something that the Commission had to create for very pragmatic, very practical reasons, because they realized that they could not do everything themselves. But at the same time, they had to respect certain principles. First of all, supremacy, and that is why you have that character of asymmetric governance within the ECN.
Jackie.
I think that was very, very complete. What would I add? I'm just thinking, I had dinner last week with the head of the Belgian Competition Authority, the head of the Romanian Competition Authority, the former head of the Greek Competition Authority, and another private practice person who just kind of sits on the sidelines, like me. I think you're right. There are huge differences of approach. As Arianna said, the Germans are way out ahead because of the history. The Dutch Competition Authority, well, for many years the Dutch believed that cartels were a very good thing and to be encouraged. And then that changed post-2004, and there was a new head of the Dutch Competition Authority, and he became whiter than white. The Greek Competition Authority, for example, thinking of crisis cartels, just to link this back, the Greek Competition Authority took a decision in 2010 against very small fish farmers, basically saying, what problems have you really got? Okay, so you're in financial difficulties. We're looking at this now 2 years later, but this is a really severe infringement of competition law. You're trying to agree prices, you're agreeing on production amounts, and you're exchanging sensitive information. Poof, big fines. And that was trumpeted as kind of a success. So the ECN indeed is an essential element of the modernization of competition law. I think, looking at it a little differently, the Commission was quite happy to give away a lot of its competences and to say to the national competition authorities, you deal with this. But I have here a report. Now, I don't know if this is the first of its type, but I just saw it yesterday, I think, and I thought, oh, this is interesting. And it's a report by the European Commission and all the competition authorities in the ECN. And it responds to a request which apparently came from the European Parliament saying, what are you doing, competition authority? I think it was addressed to the Commission, but it may have been addressed to everybody else. In the food sector, please tell us, please officially come back. And so there's this report, which is a joint report of the ECN. I don't remember seeing anything quite like that, but you might want to go onto the Commission's website and see that. And it basically, and one of the reasons why I was interested in it was because in the Q&A it says, and what about the poor farmers who are in crisis? Is it not the case that you should have a more gentle enforcement of competition policy for these particular sectors? Make it limited, make it only for the purpose of overcapacity or whatever, and the riposte from the competition authorities and the Commission globally is, no, we need to enforce competition law very severely. That's how we'll get growth.
I need to add one thing here. I think on jurisdiction, it's important to make a distinction between mergers and antitrust. In mergers, there are clear rules on jurisdiction, who is responsible, and if it's the Commission, if it's the National Competition Authority, and there are clear rules on transferring authority, jurisdiction from one to the other. So in that area, the ECN is less active, and it doesn't need to be very active. It's more active in antitrust, where the rules are less clear. And for instance, in the area of transport, there is a working group of the Commission together with the national authorities. And this example of the food sector is probably something similar, where we get together at a regular basis and discuss cases on a very confidential basis, and member states discuss their cases, we discuss ours, and this is a kind of exchange of information. And this is it's much more informal, and I think also the decision who treats what. I would not use the word supremacy. That's the message. I would say it's more a collaborative effort.
And the informality is, on one argument, is the reason it's such a success.
Yeah.
Make it compulsory, and wouldn't matter. Sorry, one more question.
I have a question, sorry, David Brew. I have a question related to social exclusion in the light of the social policy discussion that we were having this morning. It appears that competition policy may drive down prices, but there are certain parts of the population, particularly in this country, who feel excluded from the benefits of service provision because they don't get that service provision. There's transport, postal services, broadband, whatever you want to, issues associated with service obligations and so on. I wonder whether the panel has any reflections on the risks associated with driving competition policy forward from the point of view of social exclusion, and related to that, whether the logical conclusion of the driving out of cross-subsidy is that we have to have an enhanced state aid system to provide the social inclusion that competition policy might otherwise exclude.
Now, I guess it's up to me, but I'm not sure what to say.
Yes.
Let me say it again. Is the logical conclusion of the policy prescription that we have to have state aid to deal with the socially excluded,
Yes.
and that state aid, if you will, should therefore be dealt with not on a we must be convinced that it must be provided, but rather more it must be an object of European policy that state aid shall be provided to assist the socially excluded?
Unless it's community-wide aid.
In other words, a change in
It's a
the
different emphasis.
onus and emphasis of the way in which competition policy is applied to state aids.
I would say in that respect, social policy is first and foremost still a national policy in most of the EU member states. And so this implies that from a competition policy perspective, it's the member state which decides whether services of general economic interest should be provided, and then it's up for the member state to propose, to submit this proposition to the Commission, who will then check whether...
And then it's immunised. If it satisfies the Commission, it's
It's not,
immunised.
it's
with
not,
state
it's,
aid rules.
yeah,
It's fine.
it's no problem under the treaty.
If I could just say, I think there is definitely a case for saying, I mean, again, competition policy is a driver to efficiency and consumer welfare. And as a starting point, I would actually reject the idea that just as much as you cannot agree your way out of the crisis anymore, I don't think that allowing companies to make up cartels is a good way in which you can generate a benefit for the people that feel socially excluded. In other words, I take the view that coordination and collusion will only drive up prices as opposed to driving them down. Then obviously the issue becomes what services and what products are you willing to leave out of the market prescription altogether. And I think that the services of general economic interest is a framework within which you can actually make that choice. Just as much as you, for instance, mentioned the issue of cross-subsidization in certain key industries. Now, for instance, the postal sector, that was an area in which cross-subsidization had been allowed to happen. The problem is that, you know, as we say in Italy, the devil does the pots, but it doesn't make the lids sometimes. So the problem is that you would have these, this proverb. You will sometimes have companies. I'm thinking about La Poste, which was a decision in the postal sector from the late 1990s. You had the Dutch postal service, who actually, because he was allowed to sell stamps for ordinary post at a monopoly price, which could set up pretty much by itself, would cross-subsidize and then damage couriers. And obviously they were doing it supposedly to help, to help people post their letters. But then they were taking actually advantage of that. So again, I would actually prefer like you suggested, either an enhanced state aid system with proper control to ensure that, again, it is appropriate, necessary, and proportionate, rather than actually telling companies, oh, well, you know, keep cross-subsidizing, why don't you? I think that is an incredibly dangerous proposition to have.
The only response that I would give is we do tell Tesco to cross-subsidise as we tell the Co-op to cross-subsidise in remote parts of rural Scotland, effectively.
Yeah, but you see,
so we expect it to happen because we don't want to be taxed in order to provide the service, but on the other hand, it lacks transparency.
that, again,
The other way of doing it is to separate everything out and have transparency and then say, no, that's perfectly fine to do that for areas which require it.
exactly, exactly.
Okay, well,
No,
sorry, Arianna.
no.
May I thank all three of our speakers. We're all significantly wiser now, I think, about competition law, competition policy. We've had our time and then some, but it was worth staying. So thanks to all three speakers.